Perhaps somewhere along the way, you've heard of the USA television drama Suits, starring Patrick Adams and Gabriel Macht. Adams plays Mike Ross, a college dropout who happens to also be a pretty remarkable test taker with a photographic memory. Mike talks his way into a job as an associate working for successful litigator Harvey Specter, despite the fact that he has neither gone to law school nor taken the bar exam. Suits focuses on Harvey and Mike winning big cases while trying to hide the fact that Mike is not, in fact, a licensed attorney. The central premise of the show is that the skill required to be a lawyer can, in fact, be obtained by some other means than going to law school and passing the bar. A secret we lawyers don't want getting out is that the central premise is not wrong. There are all kinds of people who possess much of the same knowledge and many of the same skills as licensed attorneys. I know plenty of people that know more about the practice of law than your garden variety first year associate. You may know bureaucrats, law enforcement officers, or policymakers that understand the law deeply. The Department of Criminal Justice and Legal Studies here at the University of Mississippi is filled with very smart people who know a lot about evidence, trials, judicial decision making, corrections, contracts, and a host of other legal system adjacent topics. But they are not lawyers and are not permitted to practice law. What then is the practice of law? Well, it's the performance of substantive legal tasks for another person using legal analysis and specialized knowledge on behalf of another person, and it's a service that is usually performed for compensation. You can contrast this with clerical or administrative duties. You can also contrast this with policy making. Even lawmaking, as being a member of the legislature, is not a job reserved for lawyers. So this definition presents us with a problem, because paralegals definitely perform substantive legal tasks every day. Paralegals prepare documents for real estate closings, they draft complaints for divorce clients, research legal issues, and write memoranda explaining the application of the law to a particular set of facts. They interview clients and research the facts of their cases. They plot legal descriptions for land deeds. They write letters to clients and other lawyers and perform all kinds of other functions that if Mike Ross did them from his apartment and not a law office, he would definitely be engaged in the unauthorized practice of law. So what's the difference? Well, we suggest that it is oversight, supervision, and ultimate accountability. Let's look at a South Carolina case called N. Re Easler, in which William Randolph Easler, a disbarred attorney, continued to do legal work. Specifically, Easler drafted deeds for people and filed them at the courthouse for a fee. Now, Mr. Easler characterized this type of work as the sort of thing his paralegal would do for him when he was a licensed attorney. He admitted that he was drafting deeds and filing them for a fee, but he alleged that he was merely performing the services of a paralegal. What did the court in this case say? The evidence fails to show that the respondent's final work product was subject to the approval of a licensed attorney. Paralegal work is preparatory in nature. Paralegals might do legal research, investigation, or even draft and compose documents like deeds. But ultimately, the matter must be carried to conclusion by a licensed attorney who has reviewed the work of the paralegal. Performing legal work without a license or without the supervision and approval of a licensed attorney is the unauthorized practice of law. These types of violations occur occasionally with someone claiming to only offer administrative support or, quote, paralegal services to clients, even though they are a law practitioner by any other name. But these sorts of practices are less common than the three forms of unauthorized practice that more commonly take place inside a law office. Let's look at a few of them. The first kind of unauthorized practice of law is the improper supervision of a paralegal. From a regulatory standpoint, this gatekeeping sounds a little paternalistic, maybe even patronizing. Why can't competent professionals just perform the tasks for which their experience has prepared them? Well, let's follow that question. If you went to an office and paid good money for someone with the level of education and experience necessary to obtain a licensed practice law, and you asked that person to perform a job for you, but instead of performing that job, he passed it off to his subordinate, would you feel cheated? Would you feel confident in the work? You may or may not be fine with that arrangement. If everything works out in your favor and all the work is competently performed, there might not even be any harm. But what if the work is not performed adequately? What if mistakes are made? How do customers or clients typically respond to incompetent work? The customer looks for someone to hold accountable. I paid you to do the work. I didn't pay your paralegal to do the work. Whether the work performance of the paralegal was the cause of damage to the client's interests or not, there's every chance that the client will be hopping mad because she hired a lawyer who charged lawyer prices but gave the work to a paralegal. Practical examples of improper supervision of paralegals can include signing pleadings that the paralegal drafted without first reviewing them, using research that the paralegal pulled without the lawyer doing some follow-up, or failing to review and proofread documents like contracts and deeds that require a higher degree of specificity and accuracy than some other documents might. Improper supervision of a paralegal is essentially attorney negligence. Another form of unauthorized practice is when the attorney directs the paralegal to perform improper or unethical tasks. The most insidious form of this is when a lawyer knows that a certain act or behavior would be unethical if he acted directly, so he instructs his paralegal to act on his behalf in the hopes that the deception will obscure his involvement. Another form of this kind of unauthorized practice is similar to improper supervision, but it is the positive instruction from the attorney to the paralegal to essentially do the work for him. Lawyers who delegate all client contact to the paralegal or allow paralegals to draft and sign paperwork or correspondence or pleadings or other documents, or who send paralegals to meetings or closings, they've gone past a negligent failure to supervise and have actively and improperly shifted their obligations to another person. Finally, unauthorized practice can take the form of a paralegal failing to understand his role and improperly giving legal advice. Here's a hypothetical to illustrate. Imagine a paralegal in a small law office receives a call from his sister. The sister says, "I need to talk to Attorney Smith." And the paralegal responds, "He's busy. What do you need?" The sister says, "I think I've committed a crime, and I need to know what to do." Should the paralegal then say, "Oh no, tell me everything that happened"? Probably not. At that point, the paralegal may have suggested to the less astute sister that the paralegal is providing her with legal advice. What if the paralegal tells her to do the wrong thing? What if the advice is bad? What if the things that the sister tells the paralegal are not covered by attorney-client privilege because the paralegal is just a paralegal and not an attorney? Let's consider two more cases of unauthorized practice of law. In Louisiana Claims Adjustment Bureau, Inc. versus State Farm Insurance Company, the facts involve some overconfident negotiators. Louisiana Claims Adjustment Bureau, Inc., let's call them LCAB. LCAB held themselves out as claims negotiators who could get you a good settlement for your insurance claim against State Farm. Instead of hiring a lawyer, LCAB was trying to negotiate claims as essentially lay people. State Farm began telling folks that they should not sign up with LCAB because that group was practicing law without a license. LCAB sued State Farm for defamation, and guess what? LCAB lost because the ultimate defense to a defamation claim is the truth. Because State Farm's assertion that trying to negotiate insurance settlements for third parties was the practice of law, and LCAB was doing it without a license, State Farm was telling the truth. One more case. The facts in Lowe versus City of Sheldon are these. The parents of a child who was a claimant against the City of Sheldon appeared without a lawyer. Law permits individuals to represent themselves in court without a lawyer. This is called appearing pro se, which is a Latin term that means for myself. The parents of the plaintiff child argued that they did not need a lawyer because they were representing the family pro se. The court disagreed. Third parties, even parents of children, are not permitted to prosecute an appeal to the court, in this case, the Connecticut Court of Appeals, as next friend of the client without an attorney to represent the interests of the child. The next lecture will continue this theme of the unauthorized practice of law. However, we will delve into history a bit to understand the fundamentals of law and why there is a gatekeeping function that prevents non-lawyers from practicing law. Then, we will begin to discuss in more specific detail the kinds of things that lawyers are prohibited from doing in the practice of law, including the establishment of an attorney-client relationship and the acquisition of new clients. Let's end with a little housekeeping. Remember that this course requires completion of a syllabus quiz with a perfect score. And remember that along with the lectures in this chapter, the assignments include a substantive quiz, a case brief, and a response to an ethical dilemma hypothetical. We'll have more about the unauthorized practice of law in the next episode.